Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about excavating contracts with the City of Burnaby. Cases that should have gone to the Supreme Court of Canada, but didn't. J. Cote and Sons had an excavating contract with the City of Burnaby which was cancelled because they were involved in litigation against the City of Burnaby on unrelated matters. The City of Burnaby, in its bylaws, has a provision that prohibits the awarding of any municipal contracts to a company that is involved in litigation with the city. There's an obvious concern about this, which the Cote Company took to the Supreme Court of Canada but were denied leave. This concern is that by creating a provision that essentially prohibits a city from engaging in a business contract with a company because of other litigation, regardless of whether it's related to what the company wants to engage in a contract with the city with and vice versa, the city is ultimately preventing access to the courts. People have a right to engage in litigation. They have a right, so long as they're not engaged in abusive process or vexatious litigation, to bring their concerns to the court for a final determination. And you can't be punished in your business endeavors for engaging in litigation, and yet that's exactly, arguably, what the City of Burnaby's laws do. The Supreme Court of Canada had an opportunity here to consider whether it is even constitutional to write a provision that says that you can't get a contract with a city to perform municipal work on the basis of the fact that you're engaged in unrelated or other litigation with the city. That, to me, says that the city is trying to prevent itself from being sued by using its power to create litigation to avoid lawsuits and to reward people who don't make lawsuits against them, even where those lawsuits might be justifiably founded, and even where the city might be behaving improperly. It essentially motivates cities to pass this type of legislation and then to behave badly, knowing that they can't be sued, and if they are, they don't have to deal with these contractors anymore. That can't be constitutional, and yet the Supreme Court of Canada refused to hear the case and refused to consider whether cities can use their enormous power, which is at an imbalance as opposed to these contractors, to prevent litigation against them and to punish those who are engaged in litigation. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Please like, subscribe, and share with your friends.